Catherine. I'm managing partner of Gannon's, a commercial law firm. We work with entrepreneurs and self-employed businesses, helping them thrive. We deal with their shareholdings, their directors, their investors, all sorts of issues which arise during the typical cycle of a business, from set-up through to sale. And at one stage, often during the life of a business, they need to do a share-for-share exchange. Why would they need to do a share-for-share exchange? Well, they often need to put in place holding companies. Why would they need to put in place holding companies? Well, sometimes they want to create group structures so that they can put trades into different companies. Sometimes they want to do capital reduction demergers so that they can spin off companies. Sometimes they want to get a group structure so they can sell a subsidiary. Sometimes they need a share-for-share exchange so that they can give half of the company to warring shareholders. So there are a wide range of reasons why you might be doing a share-for-share exchange. We do lots and lots of them. They come with the great advantage that you can get Inland Revenue clearance in advance to confirm that the Inland Revenue believe it's not being done for tax avoidance. So the Inland Revenue have got this regime of tax clearances which cover a number of typical corporate reorganisation structures, which include share-for-share exchange and hive ups and hive downs and capital reduction demergers. They're the common ones for clearance in this area. And what you have to do is set out your stall and convince the revenue that you fall within the legislation. That means these transactions will not be taxed on the shareholders or the company, i.e. that they're tax neutral. And there's a skill in preparing the clearance, because you obviously need to position the information so the revenue are likely to, at a glance, look at it and stamp approval. You've got to disclose everything, but having been through the process, they give taxpayers peace of mind. Normal turnaround is 2 weeks. The revenue do have a special team that can deal with matters of urgency, but better prepared, better planning is a less stressful process. And we submit the application, we know who to speak to at the Inland Revenue, but more important, because we've done so many, we will be able to tell you in advance what your chances of success are in terms of getting clearance. Having obtained clearance, basically it says this is not being done for tax avoidance. It's peace of mind for the taxpayers. It doesn't mean the revenue can't drill down and launch inquiries at a later date if they think that tax clearance was obtained on false pretences, but in all the cases we've ever dealt with, that's not happened. The clearances have been issued by the revenue, their files have been closed, taxpayers put their tax returns in, and that's the end of it. With the share-for-share exchange, the shares in the company that you're exchanging have to mirror. They don't have to be the same number, but they have to have the same capital value and the same rights, bar an exception when you're setting up a holding company. You can have one share for the holding company. So they've got to be an exact mirror. And if they're not an exact mirror, then you can find yourself paying stamp duty at 0.5% on the share-for-share exchange. If you're not certain or not sure about the stamp duty position, it is possible to get an Inland Revenue clearance on stamp duty. If you've got an EMI option scheme, the share-for-share exchange can create problems. You have to look at the rules of the EMI scheme. Hopefully, it's got provisions in there that carry forward the options and carry forward the tax relief if there's a share-for-share exchange. The share-for-share exchange, often there's no money, so the employees wouldn't have enough money to exercise options. So you would be looking to roll over the options that may have been held in a subsidiary into options in the holding company. Interestingly, you may be putting in place a holding company where previously there were 2 separate subsidiaries, and you may want the option just in one of the companies, and the revenue permit that. It all depends on the rules of the scheme. The revenue, you have to report the share-for-share exchange to them, and that's important. And if you've got questions, the revenue can give clearance as well. So yeah, options are an issue, but often there's a solution if you know what the problems could be and work your way around them. Up and a hive down, quite common, is when you want to move assets around. You may not have a group, but you might want to split the business in two and move some of the assets from business A into business B. For example, you might have trade and IP, and you might want to put your IP into a separate business for ring fencing purposes. Or you may have assets, you may want to split assets, you may want to sell off a company. There's a lot of different commercial reasons for why you might want to move your assets around the group. Normally, you're doing a hive up, i.e. moving assets up to a holding company, or a hive down, i.e. moving assets down the group or around the group in conjunction with a share-for-share exchange, but not always. It's an area where you can get advanced clearance from the Inland Revenue, that there isn't any tax avoidance. And at the end of the day, the assets remain within the group structure, just held by different entities within the group. But ultimately, the shareholders remain the same. They're just holding shares in different companies. A hive up or a hive down is often done in advance for sale. If you know that a buyer wants to buy one part of your business but other parts of your business. It can be done to resolve disputes. If you want to share out the business to warring shareholders. It can be done for investment, where the investor wants to invest in one business and not the other. Or in the most recent case we've just finished, really interesting, they had a lot of trading activities being conducted in Malta. And ultimately this business was going to be sold, they thought, to Americans. And Americans at the moment call Malta and some of these jurisdictions grey list countries, which means it's very hard to get bank accounts open and run banks. And they're not really keen on grey list companies these days. So what that was a big hive down to move the assets in a number of these jurisdictions into England, so that there was a clean group structure ready for sale.